Many pundits raise the claim that democracy is at stake, and yet dating back to the founding days of an inchoate democratic republic, the Declaration of Independence had expressed the idea that a decent respect to the opinions of mankind requires that they should declare the causes which impel them to the separation. Yet, early in pandemic, many supporters of the government response to the global public health crisis, especially on the issue of masking guidance, had referred to a case, decided in 1905, brought to the nation's highest court by two attorneys on behalf of a minister in Cambridge, Massachusetts, who had opposed a mandate for the smallpox vaccine, and in that case, Jacobson v. Massachusetts, Justice John Marshall Harlan had reiterated a similar rule for challenging any regulatory actions if a statute purporting to have been enacted to protect the public health, the public morals, or the public safety has no real or substantial relation to those objects, or is, beyond all question, a plain, palpable invasion of rights secured by the fundamental law. It is the duty of the courts to so adjudge, and thereby give effect to the Constitution. And, in what attorneys refer to as regulatory deference, the courts have long recognized that considerable weight should be accorded to those matters entrusted to regulatory agencies, and if this choice represents a reasonable accommodation of conflicting policies that were committed to the agency's care by the statute, we should not disturb it unless it appears from the statute or its legislative history that the accommodation is not one that Congress would have sanctioned. According to the Washington Post in early June 2020, months of discord about the coronavirus epidemic had transformed the cloth mask into a potent political symbol, touted by Democrats as a key part of communal responsibility, labeled by some GOP leaders as a sign of government overreach and as a scarlet letter pinned on the weak. And, in U.S. v. Salerno, decided in 1987, the U.S. Supreme Court had observed that a facial challenge to a legislative act is, of course, the most difficult challenge to mount successfully, since the challenger must establish that no set of circumstances exist under which the act would be valid. To bring a challenge to a mask mandate, therefore, a plaintiff would have to establish that this mandate would be invalid under any circumstances. On June 20, 2020, former Governor Ralph Northam, the nation's only physician serving as a state governor during the global public health crisis, was in Fairfax County, surrounded by government officials, all masked, to deliver his weekly COVID-19 update, and he had called for 2 rounds of applause to ensure that all those gathered had understood the recent victory for DACA and Dreamers at the U.S. Supreme Court, in the decision for Department of Homeland Security v. Regents of University of California, a case that had reiterated the legal proposition that it is a foundational principle of administrative law that judicial review of agency action is limited to the grounds that the agency invoked when it took the action. Judicial review of agency action, such as the decision of the Arlington Public Schools, the second-best public school division in the Commonwealth of Virginia, to implement masking measures, is based solely upon what the agency knew, or should have known, upon a reasonable inquiry, at the time. However, if those grounds are inadequate, a court may remand for the agency to offer a fuller explanation of the agency's reasoning at the time of the agency action. In March 2021, when Arlington Public Schools began to return a gradual return to in-person instruction, the school board had updated their masking policies, noting that, according to CDC guidance, masks should be worn at all times, and the only exceptions should be for disability/medical exemption and eating/drinking. However, the policy at that time had permitted staff members to remove masks when alone in offices, or for instructional purposes, which did not align with the CDC's masking recommendation, and this less restrictive policy was discontinued. Moreover, upon the recommendation of the CDC, the school board had implemented outdoor lunch as the primary venue for safe dining, and mandated that, where in-classroom dining might occur, while eating indoors, students should be spaced at least 6 feet apart and grouped in designated/known cohorts, to facilitate contact tracing, and masks should be placed back on immediately after eating. This policy departed from CDC guidance that had stated that dining halls should be closed down and instead used for masked instruction purposes. On January 6, 2022, Superintendent Dr. Francisco Duran had stated that Omicron underscores the importance of layered mitigation to keep our schools safe and open, and had mandated universal masking inside schools and buses. On February 17, 2022, the Arlington Public School Board had announced that APS continues to review the latest health metrics and guidance regarding COVID-19 mitigation measures, while observing that the CDC currently recommends universal masking in K-12 settings, and stating that APS will continue to require masks inside our schools to keep schools as safe as possible. Under the policy, all students were required to wear a mask on a school bus, under the rationale that there is a federal requirement to mask on public transit. In Virginia, under Virginia Code January 22, 87, any parent, custodian, or legal guardian of a pupil attending the public schools in a school division who is aggrieved by an action of the school board may, within 30 days after such action, petition the circuit court having jurisdiction in the school division to review the action of the school board, and, of record, no parent, custodian or legal guardian of almost 30,000 pupils in the county of Arlington had brought a legal challenge. However, if they had, according to the controlling provision, such review shall proceed upon the petition, the minutes of the meeting at which the school board's action was taken, the orders, if any, of the school board, an attested copy of the transcript, if any, of any hearing before the school board, and any other evidence found relevant to the issues on appeal by the court. And, the action of the school board shall be sustained unless the school board exceeded its authority, acted arbitrarily or capriciously, or abused its discretion. Using this template for argument, how, during a lethal pandemic, could anyone dare to suggest that the actions of the Arlington Public Schools were in any way had exceeded their authority, had been arbitrary or capricious, or had been an abuse of discretion? Had not the CDC, on May 22, 2020, stated, the virus is thought to spread mainly from person to person, between people who are in close contact with one another, within about 6 feet, through respiratory droplets produced when an infected person coughs, sneezes, or talks, thought that his droplets can land in the mouths or noses of people who are nearby or possibly be inhaled into the lungs? Had not the CDC suggested that COVID-19 may be spread by people who are not showing symptoms?
This message was approved by Major Mike Webb. Honest.